Death and taxes are certainly unavoidable. They are also crucial to any conversation about estate planning, because if you're talking about giving your property or money, real estate, whatever it might be, to another person during your life or after your death, taxes are just simply part of the rules, and it's something you have to consider. I'm Patrick Cawley, estate planning and elder law attorney with Keystone Elder Law in Mechanicsburg, Pennsylvania, and I wanted to go through some of the basics of tax issues that come up in estate planning. First, we have to talk about gift versus estate taxes. Gift taxes are that chunk of money that come out to the government, that the government takes out of any transfer of wealth from you to another person while you're alive. You're giving a gift, the government takes a little cut of it, whatever that percentage might be. If you are leaving money in your estate, so it passes to people through your will or through your trust, then we have to talk about estate taxes. So it's a gift made after you're gone, it's part of your estate. Same thing. Here's the good news for most people who are watching this video. You probably are unaffected by federal gift or estate taxes. Right now in 2021, you have to, as a single person, give away well over $11 million before the federal government takes a cut out of that gift during your life or the bequest in your will after you're gone. And it's twice that for a married couple. So you have to give away well over $22 million before the federal government comes looking for money. Now, if you've heard, well, don't I have to file a gift tax return if I give away $15,000 to a recipient in a given year, or $30,000 for a married couple? Yes, when you give away that kind of money, you have to let the IRS know it with a federal gift tax return. That doesn't mean you pay any taxes. In fact, you don't until you get over the threshold. You've given away so much money that you're now over that $11 million or $22 million threshold. So the sky's the limit as far as the federal government is concerned for most people, especially in central Pennsylvania. That's just an awful lot of money to give away. And so most people are looking at state taxes because, of course, we pay taxes to the state as well. Here's some good news. Pennsylvania has no gift tax. So during your life, you can give money away to your children, whoever it might be, and you're not going to have any part of that gift taken out by the Pennsylvania Department of Revenue. Pennsylvania does have a tax on what goes through your estate. It's not an estate tax, it's called an inheritance tax. It's different in the sense that it's not just a flat percentage that is taken out right off the top. It changes depending on who's getting the gift out of your estate. So if it's your spouse, the tax rate is 0%, no tax. If it's going to your children, your grandchildren, your great-grandchildren, then the tax rate is 4.5%. The rate goes up if it's your niece or nephew, and then it goes up even higher if it's somebody outside your family entirely. Charities, of course, I should also mention, have a 0% tax rate. So the inheritance tax just depends on who's getting the gift out of your estate. So a lot of people will come to me and they'll if they have a vague sense that there are taxes involved, they'll say, how do I avoid taxes? How do I minimize taxes? And some even go a step further and say, do I need a trust to avoid taxes? This is all subject for maybe a longer video in itself, but here's the short version. Sometimes you'll set up your estate plan, your during life giving and your afterlife bequests in a way to minimize taxes by setting up a trust. A revocable living trust does nothing for you in terms of avoiding that Pennsylvania inheritance tax. You still owe Pennsylvania inheritance tax. A revocable living trust might be a tool if you actually do have federal tax problems, because you're giving a lot of money, and it can be used when the first spouse passes away to break the estate into two while staying underneath that very high federal tax threshold. But if you're only concerned about state taxes, a revocable living trust isn't going to do much for you. An irrevocable living trust will avoid inheritance tax under certain circumstances. So I'll do separate videos on why you might use an irrevocable trust, maybe to protect against long-term care costs. But when you put any sort of real estate or money into an irrevocable trust and 1 year passes, then the taxing agencies will consider that to be a completed gift during your lifetime. It's not part of your estate. It's not being inherited by anybody. You gave it away during your life. So you do avoid that 4.5% tax that would go to your children and your grandchildren. One other thought real quickly on tax issues is the use of insurance, because if you decide you're not just going to leave your property, either give it away during life, leave it through your will or through a trust, you might set up a life insurance policy to pay proceeds to a particular beneficiary instead, and that would be a way to avoid taxes because life insurance proceeds are not taxed in Pennsylvania. So that's another good way to go. And finally, the one other thing to consider is property issues. Don't just give your house to your children, as I've heard so many people want to do for one reason or another. There's something called the step up in basis. So you bought your home for a certain price, it gets more valuable over time. The IRS will overlook a certain amount of profit on the sale of that house, and the basis for determining how much profit is how much you paid for it. Well, if you just give your property to your children, they keep the same basis. So though they might keep the house, it will continue to get more valuable. When they sell it, they'll make a huge profit, and it might then be over the limit that the IRS will excuse, and then they have to pay a big tax bill. Whereas if it goes through your estate, then they get a step up in basis. It's no longer the floor for determining profit. Profit is no longer what you paid for it. It's the value of the property on the day you died. So then the property can get more and more valuable. Your children can sell the property at a hefty profit and not have to pay any taxes. This is pretty heavy stuff. If you have questions, shoot me an email, info@KeystoneElderLaw.com. My name is Patrick Cawley. I'd be happy to answer your questions.